In the United States, in litigation, we have the discovery of documents that are in the possession of the parties to the litigation. You have to produce essentially all of the documents that are relevant to the litigation. An exception to this are communications that you've had with your attorney. They are protected from discovery by what we call the attorney-client privilege. The attorney-client privilege means that if you have a communication with your lawyer, even though it might be relevant to the litigation, it is exempt or privileged from discovery, and you don't have to produce it to the other side. This becomes very interesting when people and companies from other countries are involved in litigation in the United States, because then the United States has to decide whether attorneys or agents, in-house counsel, outside counsel from other countries, whether their communications with their clients are privileged and thus don't have to be produced during the litigation. There are different rules from different courts. Some are more strict, some are very strict. So you have to understand that there is, though, a solution to the issue, and that is all the courts in the United States consider privileged the communications that you might have with U.S. attorneys. In addition, under U.S. law, if the communications are designed to develop information or gather information to assist an attorney in rendering legal advice, then those communications are also privileged. So a solution for a Danish, a Swedish, a Norwegian company that has a question of U.S. law is to get a U.S. attorney involved immediately. In fact, the very first internal communications can begin with the simple phrase, in order for us to gain legal advice from our U.S. counsel, we need to, and then you explain the kind of information you want gathered. Those kinds of communications, no matter who they are from the president of the company, in-house counsel, officers, employees, it doesn't matter. Under U.S. law, because those communications have been made to gain legal advice from U.S. counsel, they will all remain attorney-client privileged in the United States, and you don't have to produce them during discovery in the litigation.